Welcome to our deep dive into immediate relative green card processing and why the word immediate does not mean instant approval. We will unpack timelines, milestones like biometrics and RFEs, how to work legally while you wait, when litigation becomes an option, and the hidden variables that change outcomes. Let's get started and set realistic expectations. Here is our roadmap. First, we will clarify what immediate relative means in immigration terms. Next, we will address the myth of instant approval timelines. Then, we will cover the most common milestones that cause delays, including biometrics and requests for evidence. After that, we will discuss how to work legally during the pending period by using an employment authorization document. We will continue by exploring when to consider litigation, specifically a writ of mandamus. Then, we will examine hidden variables, such as method of entry and age, under the Child Status Protection Act. We will also provide practical planning strategies for students and families. Finally, we will test your knowledge with quick quizzes and finish with key takeaways and next steps. Before we proceed, please note this is general educational information and does not constitute legal advice. Individual facts matter enormously in immigration, and timelines frequently change. You should consult a qualified immigration attorney to evaluate your specific situation. With that in mind, let us continue. Let us start with definitions. Immediate relative means the immigrant visa category for certain close relatives of U.S. citizens with no annual visa number limit. However, this does not skip the government's operational backlog. Cases still line up for biometrics, security checks, and adjudicator review. So while there is no priority date queue, there is still an administrative queue. That distinction drives most of the timeline confusion. Now, let us confront the myth directly. No backlog does not translate into no waiting. Published estimates, sometimes showing as high as 58 months, often reflect complex or outlier cases and the workload at heavily burdened service centers. Even straightforward immediate relative filings commonly run 18 to 30 months from submission to approval. The primary bottlenecks are security checks, file transfers between offices, and limited adjudicator capacity. Be prepared for variance by location and case mix. Next, let us break down the milestones that shape your timeline. First, biometrics verifies identity and collects fingerprints and photographs to run background checks. Completing biometrics is necessary, but does not guarantee faster adjudication. Second, an RFE, or request for evidence, indicates an active case that needs more documentation. Common requests include the medical examination on Form I-693, proof of the petitioner's U.S. domicile, and updated financial evidence for the I-864 affidavit of support. Once you submit the response, the case re-enters a new review phase. Many cases are approved after a successful RFE response, but this still may entail additional months of waiting. Moving on, let us address lawful employment while your I-485 is pending. The A number alone does not authorize work. Instead, you must file Form I-765 for an employment authorization document. Many applicants submit the I-765 concurrently with the I-485 to start the clock immediately. Processing times vary by center, but commonly take several months. Once approved, the EAD allows you to complete Form I-9 and begin legal employment. If international travel is necessary, consider filing Form I-131 for advanced parole, which may be issued as a combo card with EAD in some cases. If your permanent resident case remains pending and your EAD is approaching expiration, submit a renewal early to avoid gaps in authorization. To put the pieces together, this timeline offers a generalized view of how time is often distributed across an immediate relative I-485. Expect receipts and biometrics within the first few months. Initial review and background checks can extend close to a year. The RFE window often appears around the 1-year mark, followed by a post-RFE review that can add additional months. By the 2-year point, many cases reach decision, though some take longer. Use this as a planning tool, not a guarantee. Quiz time. The question is, true or false? Being in the immediate relative category means you should receive your green card almost immediately because there is no visa backlog. Option A, true. Option B, false. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is false. While immediate relative status eliminates the visa number backlog, applicants still wait in administrative queues for biometrics, security checks, and adjudicator review. That is why even clean cases can take 18 to 30 months. Now, if your case stretches far beyond normal processing, often over 2 years, especially after submitting all requested evidence, you may explore litigation. A writ of mandamus asks a federal court to compel the government to act on your case. It does not order an approval. It compels a decision, whether approval or denial. The benefits include prompting swift agency action. The downsides are cost, legal complexity, and the lack of guaranteed outcome. This is a strategic choice best evaluated with an experienced attorney. Here is a practical table of common RFE items. The I-693 medical exam is essential for admissibility and must be completed by a designated civil surgeon and submitted in a sealed envelope. Proof of petitioner domicile verifies that the sponsoring U.S. citizen actually resides in the United States, supported by housing, utility, identification, and employment documentation. The I-864 financial evidence demonstrates the sponsor's ability to support the intending immigrant, typically including tax transcripts, W-2s, and employment letters. Household member sponsorship via I-864A may be needed to meet income thresholds, with full signatures and evidence. Finally, updated employment or asset documentation can be requested to confirm ongoing eligibility. Let us compare two commonly confused items. The A number is simply your USCIS identifier and appears on many notices. It does not authorize employment and is mainly useful for tracking. The employment authorization document, obtained via Form I-765, is a physical card used to complete Form I-9 with employers. It authorizes legal employment in the United States and can be renewed while the adjustment application remains pending. Now, let us examine the hidden variables that can lengthen processing. First, the method of entry matters. Applicants not lawfully admitted or paroled may be ineligible to adjust within the United States unless covered by provisions such as INA 245I. Second, age can be critical. If the applicant is approaching 21, the Child Status Protection Act calculations can preserve eligibility as a child and prevent a category change. Third, background factors such as prior overstays, immigration violations, or criminal history can significantly extend review times and increase the likelihood of interviews and additional evidence requests. Here is your second quiz question. Which document authorizes you to work while your I-485 is pending? Option A, your A number. Option B, your I-94 entry record. Option C, an EAD card based on Form I-765. Option D, the I-485 receipt notice. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is an EAD card based on Form I-765. Only the EAD or the green card authorizes employment. The A number and the I-485 receipt notice do not provide work authorization. Finally, let us focus on planning for students and families. Start by building 6 to 12-month buffers around college start dates, financial aid verification cycles, and internship recruitment timelines. Next, research state-specific residency rules for in-state tuition. Some allow alternatives to permanent resident status. Confirm scholarship eligibility well in advance, because certain programs will accept pending status or an EAD. If delays persist, prepare contingency plans such as EAD-based employment, a gap semester, or deferring admission to protect long-term goals. To wrap up the core lessons, immediate relative status avoids visa number caps but not agency queues. Use the I-765 employment authorization document to work legally while you wait. A timeline of 18 to 30 months is common, with potential for longer cases. Respond thoroughly and quickly to RFEs, as strong submissions can trigger approvals. If the case stagnates beyond 2 years, evaluate a mandamus action with counsel. Finally, remember that method of entry and age under CSPA can alter eligibility and timing. This timeline diagram shows the adjustment journey from filing through decision. The leftmost segment represents filing and immediate receipts. Shortly after, biometrics occurs, enabling background checks. The central blocks represent the longest phases: initial review, and potential RFE issuance. After the applicant responds to any RFE, the case returns to post-RFE review. Finally, the decision and card production close the process. The time windows reflect common ranges, but will vary by case and location. In summary, immediate relative status does not guarantee immediate approval. Expect administrative queues, potential RFEs, and variable timelines influenced by local workloads and case specifics. Use the EAD to lawfully work while you wait. If your case faces unreasonable delays beyond 2 years, consider whether mandamus litigation is appropriate with counsel. Pay close attention to method of entry and age considerations under CSPA. Finally, build planning buffers around critical school and work milestones. Thank you for watching. If you found this helpful, please like the video, share it with someone navigating the green card process, and subscribe for more practical immigration guidance. Tell us in the comments how long you have been waiting, what milestones you have passed, and what you want to learn next.